All right, so thank you all for joining us for this presentation, and thank you for being patient with us as we dealt with technical difficulties. My name is Paige, and I'm the training coordinator with DC Safe.
My name is Cameron, and I'm also with DC Safe as the Lethality Assessment Project Coordinator.
So today we're going to be going through the training for our CourtWatch project. And to start off, we'll talk a little bit about SAFE as an organization, and then we'll talk a bit about where the CourtWatch project came from and what we use it for today. So to give you a little background on SAFE and who you'll be volunteering for, we are the 24-hour crisis intervention organization for domestic violence in Washington, D.C. So the majority of the services that we provide as an agency are working directly with survivors of domestic violence right after some kind of a crisis has happened. So we're working with folks to get them in safe housing, to safety plan with them, get them access to counseling, and a big piece of the work that we do revolves around the civil protective order process. So the CourtWatch project is one of the oldest projects that SAFE has been working on. It's really a court accountability project. So our volunteers will sit in courtrooms and they're documenting demographic information about the parties in the case. And we're looking at that with the outcomes of those cases. And so in aggregate, on average, last year were about 5,000 cases that were filed. We're collecting data on about 1,200 of those cases. So we're looking to see what patterns are present in the way that judges grant or don't grant, or what provisions they grant within the protective order process. We're also interested in looking at judicial behaviors. So because we're a direct service organization, we're really focused on making sure that the systems work for the survivors, right? The system can function on itself, but we want to make sure that the folks who are accessing it get what they need from it, and get what they need from it in an equal way.
And the CourtWatch project seeks to help our survivors and advocate for system reform through multiple facets, one of which is a regular blog that is put out by DC Safe that you can view on the DC Safe website, and basically gives analysis and reporting of judicial behaviors observed or outcomes for survivors observed through the CourtWatch project. We also have a agreement with the courts to take the numbers back to the judges for judicial training to basically let them know when their bias is showing, or when there are outcomes that might not be in the aggregate wholly fair for survivors of domestic violence, so we can affect judicial behaviors in sort of real time. Finally, it is also utilized in a yearly report that is circulated throughout the domestic violence community and many of our agency partners, called the DV&DC report. So the CourtWatch project actually is utilized in many, many, many ways to help our survivors get better outcomes in the local courts. And as Paige says, this is a 100% volunteer project. Our advocates are busy trying to help those clients in crisis, and they're not there advocating or observing these trials the way you guys are. And so that's why we rely upon your volunteer hours and your efforts to be able to make this a successful project.
And so before we begin, what we're going to review today, we're going to go through the process. So you all are going to be coming in at the tail end of the protective order process, the day that folks show up for their civil protective order hearings. We are going to talk about the process from beginning to end. At the end, we're also going to talk about what your role is and how you're going to be collecting the data. So it's a really fun time for us because we've now moved from a paper system to a tablet system, and we want to make sure that we're collecting quality data and we're doing it in a time-efficient manner. So before we get started with the presentation, we're going to go through the attachments that I should have emailed to you. If you didn't get those, feel free to reach back out to make sure you get them. The first is a CourtWatch frequently asked questions sheet. This is the one-stop shop for all of the information that you're going to need to know about volunteering with the CourtWatch project. It's got the information for the tablets, how to access the tablets, which app to use once you log into that tablet, how to save forms within that. We want to make sure that when you're capturing this fantastic data that we actually get to save it so we can use it later. It also goes through the courtrooms that you will be observing in, as well as the times that our shifts are allocated for within those courtrooms. And then how you sign up for court shifts. So because we have limited access to tablets, we're a small nonprofit, we don't have many tablets, we can only have one person in each courtroom at any given time. So we want to make sure that if you're coming in for CourtWatch that you have previously signed up on the CourtWatch calendar.
Yep. And we would say that this CourtWatch frequently asked questions sheet should be your first recourse if you have any questions. It will answer 90 to 95% of the questions that you have regarding this project. Like we said before, our advocates are focused on client services and not on the CourtWatch program. They are there available to answer any questions that you may have, but if you can, bring this frequently asked questions form with you. If anything comes up, utilize that first before asking an advocate for any questions or any assistance.
The next form you should have is a flow chart, and this is what we're going to be talking about today. It's the process for obtaining a protection order. We're not going to go through this piece by piece, but this is a reference guide for you in case you forget a couple of the steps that go along with the protective order process. You will also have a paper copy of the form that we use for data collection. So again, we're using tablets now, but the paper form that we sent you is it's most of the information that we're collecting on the tablets. We use paper forms in case of emergency if the tablets shut down for some reason, but this is just a quick reference guide for you.
Just know that anything that you fill out by hand, an advocate here is going to have to enter manually into our data set, and so we much prefer you utilizing the tablet over the forms. If we got to use the forms, we got to use the forms, but please use the tablets whenever possible.
The next form that we have is our acceptable use agreement. So we have gotten special permission from the courts to be able to use tablets in the courtrooms, meaning that no one else in that courtroom is going to be using any tablets or laptops or cell phones. And so the tablet, when you pick it up, has a special sticker on the back of it that shows that you are a CourtWatch volunteer. And because these are tablets and you are working inside the courtrooms, we want to make sure that you are utilizing them in the way that they are intended to be utilized. So we need you to sign this acceptable use agreement, basically stating that you're only going to be using the tablets for the purpose of CourtWatch. You're not going to be using the cameras, and you're not going to be surfing the web, looking at other websites while you're in the courtrooms doing your volunteer shifts. Nothing
will sync this project faster than a volunteer surfing the web or playing a game on their tablet while the court is going through proceedings. So please, when you utilize this tablet, you are only utilizing it for CourtWatch.
And the last form that we have is our confidentiality agreement. We did mention that we are a direct service provider, and while everything that happens in these courtrooms is public, you are possibly going to have information available to you that other folks might not have information available to them. So when you come in, you're going to get a copy of the day's docket. That docket is the same docket that's used by our advocates internally. So there might be markings on there showing which clients that we are working with as an organization. You might see or hear our advocates talking to clients about information that's not publicly going to be available through the court system or through the court process. So we want you to, one, make sure that any information about individual client cases that you witness, that you're keeping that confidential. Again, this is domestic violence court, and so these court proceedings do have an impact on this person's future safety. The next is if you happen to come across any information about our funding mechanisms or where we're moving with our CourtWatch program. Again, these things are specific to SAFE, and you're working in a capacity for SAFE. So please make sure that you're not sharing any of our forms, you're not sharing any of our data that's not publicly accessible with folks outside of the agency.
So to participate in the CourtWatch program, before we can give you a tablet, before you can do anything, we will need copies of the confidentiality agreement and the user agreement before anything starts. So for those of you who did not come to any in-person trainings and did not get a paper copy of this, we're going to need you to basically print these out, fill them out yourself, and email them back to Paige before signing up for any CourtWatch shifts. It's going to be the only way that you can participate in this program.
And if you have any questions about that, feel free to send me an email as well. All right, so we're going to go ahead and get started with the presentation.
So first things first, we just want to let you know a little bit about where you're going to be operating as a CourtWatch advocate. Basically, as Paige said, the CourtWatch program is there to assist and observe behaviors of judges and outcomes of the civil protection order process. DC has a very unique process or for the civil protection order procedure that may be different than other jurisdictions that you're coming from. DC has decided to make their own domestic violence court, and they have married criminal cases with civil cases within that court. At this time, DC Safe's CourtWatch program is only dedicated to observing judicial behaviors and outcomes in the civil protection order process. Anything that is criminal, we are not observing at this time, so you do not have to observe them. And you're going to figure that out by the docket that you're going to be getting in the mornings when you come in. Okay, if something has a DVM case, if it says DVM instead of CPO, that's a criminal case. If something says CCC instead of CPO case, then both of those are criminal. Okay, if you don't see anything that tells you that way in the docket, there's some other notes that you might be able to utilize to figure out the difference between the civil and the criminal. So civil is a forum for private parties to resolve their disputes. It's one person against another person. It is Jane Doe versus John Smith. All right. Criminal, it is the government against a party. So it will be U.S. versus John Smith. If you don't see two separate parties, chances are you're going to be viewing a criminal case. Okay. The judge acts as a neutral party to decide the issues based on relevant law and interests of the public policy and justice. And they do so in what we call by a preponderance of the evidence or for good cause. Basically, the judge decides facts, what he believes more. I am 51% sure that the petitioner has a good cause for a civil protection order, or I'm 51% sure that this intrafamily offense, and we're going to get to that later, occurred. That is what can lead a judge to a ruling within a civil court. The burden of proof is much higher in criminal court, as you guys may know from Law and Order and things like that. It is a beyond the reasonable doubt standard. Basically, you have to be sure that this happened. If a judge is talking about preponderance of the evidence or good cause, chances are he's talking about a civil case. If he's talking about a beyond the reasonable doubt, chances are he's talking about a criminal case. Okay? Civil court, you're not entitled to an attorney. Criminal court, the defendant is entitled to an attorney. The U.S. will always have an attorney. So you can always check for those attorneys. Okay? If they utilize words like petitioner and respondent, that's a civil case. A person that is filing the case is petitioning the government to order something, and whoever is answering that petition is the respondent. He is responding to the petitioner. Petitioner is the person who filed. Respondent is the person who is answering. Those are the two parties to the case in a civil case. Criminal court, like we were saying, state prosecutes the people, U.S. v. whomever. In a criminal case, there will always be a victim, but the victim is not a party to the case. They are a witness for the prosecution. So even if a victim says that they don't want to go forward with a case, the government still has the option to go forward with that case because it's the government's case, it is not the victim's case. The victim may be involved, the victim may be there, but it is not their case. You are entitled to an attorney in criminal court, and penalties can be 6 months or more of jail time. Okay. So, what people are filing for in the Civil Protection Order Court is a temporary protection order or a civil protection order. The difference between a temporary protection order and a civil protection order, and this is key because you're going to be hearing both in the court, whether a judge is going to be granting a temporary protection order, extending a temporary protection order, dismissing a temporary protection order, or granting a civil protection order. They are essentially the same type of orders requiring respondents to abstain from particular acts against the petitioner for safety, to promote the safety and welfare of the petitioner. The difference really is time, or length of time that order is in effect. A temporary protection order is only good usually for 14 days unless continued by a judge by the consent of both parties. So if they're talking about 14 days out, it's usually going to be a temporary protection order. Okay, civil protection order is good for a year, and it can only be issued after a hearing, either with both parties present or one party waiving their right to be there. And that's what we call a default judgment. And we're going to get to that in a little bit. Okay. A temporary protection order, a civil protection order may be applied for if there is an intrafamily relationship between the parties, the respondent has committed a crime against the petitioner, and the petitioner is a D.C. resident or the incident occurred in D.C. So these are going to be the three things that a petitioner needs to prove by a preponderance of the evidence or by good cause that a judge has to find. That one, they have this relationship that allows them to be in DV court, that there is this crime that has been committed against them, and that the court has jurisdiction by the petitioner either being a DC resident or having an incident occur in DC. So those are three separate elements that need to be proved by a petitioner, whether there's going to be a default hearing, whether there's going to be a contested hearing. And we're going to get to that in a bit. Okay. So the first element, an intrafamily relationship. Intrafamily relationship is what brings something to the domestic violence court as opposed to another court, like a civil court or a restraining order court or any other court like that. That intrafamily relationship is basically what you think an intrafamily relationship is. Blood, legal custody, marriage, having a child in common. Some things that are unique to DC is they also cover people who share or have shared a mutual residence, roommates. They include same-sex couples. They allow minors to file. They allow you to file against a common intimate partner. And then a common intimate partner is basically an ex-partner of your current partner. So my girlfriend's ex-boyfriend came and hit me, I can file against him. Okay? Sexual assault survivors, if there is no other relationship, except for that one incidence of sexual assault, they can still file, okay? And if somebody is stalking you, even if there is no other relationship, you can still file in TPO, CPO court, DV court.
Yeah. And so you're going to be looking for, as much as you can, these relationships. This is one of the things that we're going to be asking you to try and document. This isn't something that's necessarily going to be stated out loud, but you're going to want to try and figure out, based on what you see in court, what you believe that relationship is. And there can be multiple of these relationship types checked off at one time. So someone might have a previous dating or sexual relationship, and they might also have a child in common. So feel free to check off multiple boxes if you believe there are multiple types of relationships between the two parties.
Okay, so the temporary protection or civil protection order process. And we're just going to go over this really quick just so you understand what you're looking at. Somebody meets the requirements for a protection order. They have those three elements that we were just talking about. They can come and file a petition at the Domestic Violence Intake Centers in D.C. One's at the D.C. Superior Courthouse. The other's at United Medical Center in Southern Avenue Southeast. Okay? They basically fill out a petition, a form that basically states what your relationship is, what the crime is that happened to you, and what you're asking the court to order the respondent to do. That will get you on the docket for a TPO or a CPO hearing within 2 weeks. You can also request at that time a TPO for immediate protection between now and that hearing within 2 weeks. All right? If you request that temporary protection order, you will go in front of a judge same day. Judge will ask you, the petitioner, in an ex parte hearing. An ex parte hearing is just basically you and the judge. There is no other party present, about the elements to be proved, right? Whether there was an intrafamily relationship, whether a crime occurred, and whether you are a D.C. resident or the incident occurred within D.C. If the judge finds good cause that those three elements are there, they will issue a temporary protection order. Most people get the temporary protection order. I think it's like 85 to 90% of petitioners who request a temporary protection order will get that temporary protection order. Okay? The court will set a date for 2 weeks from the day that you filed for the civil protection order hearing. So for that hearing for that year-long order. That protection order that and a notice in order to appear and the petition that was filled out will be generated in what we call a service packet. Protection order is only going to be valid if a person, the respondent, knows that the protection order is in effect, basically. Okay? If a judge orders a temporary protection order, there are certain remedies that are immediately available, such as custody and the like, that does not require service. But to have somebody held criminally liable for violating a protection order, they need to know this in effect. And that's where service comes in. There's two ways to serve somebody. Either personal service, which is kind of a misnomer. Anybody who's not the party or an interested party in the protection order hearing and over the age of 18 can serve that person, or the Metropolitan Police Department can serve them. Okay? Once that service happens, then the protection order is punishable, and the offender can face up to 180 days in prison, a $1,000 fine, or both for violating it. Okay? And that service of notice allows that respondent to be able to know that there's a hearing within 2 weeks. A return of service is necessary for the court to make any decisions or rulings on the civil protection order at that hearing in 2 weeks. And it is one of the most integral parts of the civil protection order process that survivors have to deal with throughout their time in the temporary protection or civil protection order process.
Yeah. And so at that point, this is what we see is the biggest barrier often for a lot of folks when they're coming to their civil protective order hearing. What you're going to be witnessing that day in court is that they were unable to serve the respondent. So we'll talk about court outcomes in a minute and what the different options are. But when they come back for that hearing, if they do not have that return of service, either from their person over the age of 18 who they're getting to serve or from MPD, the case cannot be heard that day.
And this is key for all of those of you who sign up for morning shifts. This is really what we're trying to track in those morning shifts is service issues and how the court reacts to service issues. Whether a judge becomes annoyed or starts showing bias or starts treating a survivor badly because of service issues or dismisses cases due to service issues. Those people that are going to be in those morning shifts, that's what you're going to be tracking mostly. Okay? So let's say the survivor or the petitioner shows up for their court date the day that's set. The court's first going to figure out whether there was service, or they're first going to figure out whether a respondent is there. If the respondent is not there, they're going to figure out if there is service. If there is service and the respondent's not there, they will issue what we call a default order, basically saying the respondent waived his right to the hearing, he agrees to whatever the CPO is going to be, and they are going to issue what we call a default civil protection order and swear out a bench warrant for the offender to be arrested. He'll be arrested, he'll be brought into court just to be served the paperwork and released again. Okay? If there is no service, then they will either dismiss the case for service issues, or they will continue the case to be for the offender to be served at a later time, usually just another 2 weeks. And then they will decide whether they need to extend the temporary protection order or not have to extend the temporary protection order for those 2 weeks. Those are things that you're going to be tracking in that morning session.
So when we talk about dismissals, there are two types of dismissals. The first is dismissed with prejudice, and the second is dismissed without prejudice. So when you're filling out your tablet form, when you get to the result section, you're going to have to choose between the two of those. The default is going to be dismissed without prejudice. We see dismissed with prejudice very infrequently. If you hear someone say dismissed for failure for want of prosecution, that is dismissed without prejudice, meaning that the petitioner can come back and use the same incidences that they listed in this petition to refile at a future date. If something is dismissed with prejudice, that means that they cannot use those incidences that they filed on to refile, meaning that there has to be something else that they're bringing in to refile for a protection order. We see it very infrequently, so if you don't catch it, opt to dismiss without prejudice.
Right. So judges usually utilize dismissed with prejudice only if they believe that a petitioner is abusing the system, and they don't want the petitioner to abuse that system utilizing these incidences ever again. If I see, or the advocate that is looking over the data set sees a dismissed with prejudice, we're going to have to go back actually into our court system to see whether that was actually dismissed with prejudice, just because it is so rare. And that's why Paige says default is probably going to be dismissed without prejudice. You're going to see on your tablets reasoning behind that dismissal as well, okay? And usually that's either going to be service issues or dismissed at petitioner's request or dismissed because nobody showed up, okay? It's important to figure out why that dismissal happened and note that as well. Okay.
So one thing that we kind of talked about too, so if the petitioner does not show up for the court date, the case is going to be dismissed. The petitioner is not going to face any fines, or not going to face any punishment for not coming, but we do see that very often, for whatever reason, petitioners are unable or don't come to court. So if the petitioner is not present, the case will be dismissed.
Okay. So if the petitioner shows up and the respondent shows up, both parties will then go into a room with an attorney negotiator, or two separate rooms with an attorney negotiator, to see if they can come to an agreement about the case, either dismissing the case or having the respondent consent without admissions. Consent without admissions means I agree to the terms of this protection order, but I don't admit to the crime that you stated in your petition that I did to you, okay? And the negotiator is trying to reach that agreement, right? Leaving off certain remedies or reducing certain remedies to come to that agreement to not take up the judge's time. And what you'll see if that actually happens is that the judge will call up the parties, say, hey, is there a consent to this this protection order? The judge should confirm with both parties that they consent to the terms of the protection order. They should read over the terms and the remedies of that protection order and ensure that both parties agree to the protection order before going forward anymore. And you'll see a lot of that in the morning sessions as well, okay? You'll also see a lot of that in the afternoon sessions.
So most of the cases they're going to be consents without admissions. There is an option for a consent with admissions. You're going to see that a lot less frequently. Often that'll happen if they've already been convicted of the criminal case through criminal court for the incidences that are listed in the petition. So most of the time, again, if we're talking about falling back, if you hear it's a consent order, we're going to fall back on assuming it's a consent without admissions. But it very well may be that there is a consent with admissions, often if they've already been convicted of a criminal case.
Like Paige said, it's very rare. If the advocate who's looking at the data set sees a consent with admissions, we are going to go back to that case to ensure that it is an actual consent with admissions because it is so rare. So if nobody wants to consent to the order, that's when a contested hearing occurs, okay? And that's everything you see on Law and Order, okay? There are people presenting evidence, judges making rulings, okay? It's basically what you come to expect when you're, or came to expect when you signed on to this CourtWatch project, okay? A lot of that is going to be in the afternoon. The majority of that is going to be in your afternoon shift. Okay, I just want to let you know that even though those contested hearings are very important and we do want to get all the data set from those contested hearings in the afternoon shifts, we definitely need people to sign up for the morning shifts because how a judge treats a petitioner when there's service issues is just as important as how a judge rules in a contested case. So if you are going to sign up for CourtWatch, please at least sign up for 1 or 2 morning shifts as well.
And there's going to be a very different pace. So you might see one case might take up your entire afternoon session as opposed to the morning session. It's a lot faster of a pace. So you're going to have a lot of different cases that you're hearing. So just be aware, too, that the pace is different. So getting a taste of both of them is really helpful when you're doing your CourtWatch volunteerism. So the last piece, so when they go to that hearing, the hearing, the judge will make a decision whether to grant or deny the protective order. I think we know that last time we did the data set, it was around 70% of contested hearings led to a protective order being granted. I think that's what the last data set said. So if you stick around for the end of the trial, you're going to want to see, was that protective order granted or denied?
Okay.
All right.
And as you observe that contested trial, okay, as you observe what the judge's ruling is, the judge should be justifying his or her ruling, right? And the judge should be finding for those 3 elements. They should say whether there was an intrafamily relationship, whether there was a crime committed, and whether they have jurisdiction over it, okay? And they should be detailing what remedies were granted and what remedies were denied. And it's as important for us to figure out what remedies may have been denied in a granted protection order as if a protection order was granted or not. So make sure you are paying close attention to the remedies that are granted when a judge rules.
So just to review the case outcomes, a case can be dismissed, that's with or without prejudice. A case can be continued, that can either be by the request of the petitioner or the respondent for failure of service. There's a variety of reasons, but that case can be continued. There could be a default result. So if the respondent was served successfully and did not appear in court, they then waive their right to respond to the allegations. The judge is going to grant a default order. Then there's a consent order, meaning that the parties met with the attorney negotiator, they came to a decision. It's either consent with admissions or consent without admissions. And finally, with the contested hearings, the judge is going to then decide whether they're going to grant or deny a civil protective order.
Okay, so like we were saying, a judge may grant a protection order but deny certain remedies or reliefs, okay? And so you want to be sure that you know what type of remedies or reliefs are available for a protection order. The standard ones are what we call a no hats order, no harassing, assaulting, threatening, or stalking a petitioner. It's one of those things that says you can't do something that was already illegal already. Okay, it's the bare minimum of a protection order. It's always going to be issued with every protection order. Okay, then we get into things that are in addition to what is already illegal. The standard is usually a stay away from the petitioner. If they don't say how many feet, it's usually 100 feet. If they're telling you it's something less than 100 feet, that's something to note. There's a no contact of the petitioner. If you have phone, writing, or third parties. Attending drug or alcohol treatment programs for the respondents, domestic violence classes, attending that as well. Remediation or payment for damage to property or medical bills or other bills incurred due to the resulting of violence. And then possibly child or spousal support for the duration of the order. Okay. Some other ones, vacating of the residence by the respondent, custody and visitation of the child. That's usually going to be one of those things that may be denied in a civil protection order, usually due to the fact that there's already pre-existing custody order or whatever, something that we definitely want to note because in the domestic violence realm, co-parenting is very important, moving on from a protection order hearing. So protections regarding custody is very important. Counseling, costs for attorney's fees, and the return of private property, particularly the keys to maybe a shared residence. Okay. As I said before, if an offender actually violates a protection order, they face up to 180 days in jail or a $1,000 fine. It's an actual criminal offense. It's basically after this protection order is granted by a judge, this protection order creates a DC law that is specific to that one individual that they can't do whatever that judge says. If they do, they have violated the law and they do face criminal punishment.
The last thing is, so a petitioner can never be arrested for violating their own order. So again, the respondent is the one who's responsible for upholding all of the judge's orders.
Okay, we talked a little bit about service of TPOs, CPOs. You can read through this later. Okay, after a protection order has been issued, a party can make a motion to the court at a later time to modify or vacate or remove the protection order. They can vacate certain provisions of protection order. They can ask for additional protections in that protection order. They can do a whole host of things. And so there may be some trials that you are going to see that are actually not initial trials for the initial granting of a protection order, but actually a modification or removal of the protection order. If that is the case, make sure that you note so in your notes that this is a modify, a vacate, or an emergency motion, just so that for our data set we know what is going on with that particular trial. Okay? Okay, so let's get into the nuts and bolts of everything. If you have any questions regarding the protection order process or the hearing or things that you're going to be observing, you can go ahead and email Paige. Make sure you email Paige at her DC Safe address. For anything that is the nuts and bolts things, like I say before, please refer to your frequently asked questions sheets first. Come back to this training second. Everything that you need to know should be here. Okay? So first things first, how to sign up for shifts. Like Paige said, we are a small nonprofit and we don't have a lot of computers available. We have 2 tablets available for this CourtWatch project. So only one person per courtroom per shift is going to be allowed to do CourtWatch. And so we want to make sure that not everybody's signing up for the same shift. So we are going to have a communal calendar. And that communal calendar is going to be on the CourtWatch email. And it's just like any other CourtWatch, Gmail account. Is CourtWatch the username is courtwatch@dcsafe.org. The password is advocate09. And you can see it on your PowerPoint. You can see it in your frequently asked questions. Okay? You're going to go immediately to the calendar app, which is going to be in the top right-hand corner. Once you log into that Gmail, you'll see a little calendar button. Press on that calendar, and this should populate, and what you're seeing in front of you should populate. Okay? Pick the day that you want to volunteer. Click on that day, and then a little dialog box will open up in front of you like you're seeing on your screen now. Okay? What we need you to do is enter in the starting time and the end time of your shift, and you cannot vary these. Okay, the start time is always 9:30 a.m. to 12 p.m. or 1:30 a.m. to 4 p.m. because we need to be able to switch off those tablets for the people for the next shift. Okay, you put the start time, end time, your name, the room that you want to do, and then the name of your shift, either the AM shift or the PM shift.
Yeah. And so the court watch shifts are also Monday through Friday. If there is a federal holiday, the court is closed. We will not be doing court watch shifts. So not the weekends, not federal holidays, just Monday through Friday. These are the times.
Okay, so yes, Paige is right. Monday through Fridays and federal holidays for you winter people that are volunteering during the winter months. There are snow delays and snow cancellations for DC courts. Check the DC court Twitter feed before doing that. If the court is delayed, it will be delayed till usually around 10 a.m. You can start your shift then if you want. Just make sure that you are still wrapping up your shift by the 12:30 p.m. time frame, just because other people will be coming in after you to volunteer.
Yep, and if you're unable to make a shift, don't worry about emailing me. You can just take your name off of the calendar, and that's perfectly fine. So no need to email if you're going to miss a shift. It's perfectly acceptable. Just make sure that you remove your name from the calendar, so if someone wants to sign up in that shift, that they have the availability to do that.
Right. And as you can see, these shifts, they are 2.5 hours long, usually. We request that all volunteers in a academic semester sign up for at least 4 shifts, okay? Because your first shift, you're just getting your feet under you. You don't really know what you're seeing. Everything is kind of chaotic, and you're drinking from a fire hose. So we want that second shift to be able to actually get that good data from you. And if you're going to be viewing both shifts, then we're going to need basically those 4 shifts from you for that academic semester. If you don't think you can make 4 shifts, that's completely fine. But we really, really, really suggest and recommend at least 4 shifts in an academic semester.
And finally, we have the second shift ends at 4 p.m. We really need you to get those tablets back to us by 4 p.m. at the absolute latest. Even though a court case may be going beyond that 4 p.m. marker, you might not get all of the data for that hearing. Our offices close at 4 p.m., so we do need those tablets back by 4 p.m.
Okay, so this is a real quick tutorial on how to utilize the CourtWatch app. Usually when you log into the tablet and the login password is password 15 with a capital P, you'll see it on your frequently asked questions. It should open up automatically in the Smart Forms app. If it's not, just click on the little button that says Smart Forms. The button is shown on your frequently asked questions sheet. You should see when the Smart Forms app is open, a thing that says CourtWatch. Click on CourtWatch. Okay, it should populate a number of records. Don't go into any of the records that are already populated. Those are completed forms, okay? Those are things that are already saved. We don't want you messing with any of that. Click on the plus sign at the top of the screen that says Add a Record. Now, a form is going to populate that you can scroll through and add information as you acquire it. There are certain fields that are required to save a form. If you don't put in these fields, you will not be able to save the form. Luckily for you, all of these required fields are going to be available on the docket when you collect it. So you can pre-fill these forms out before the case starts. Case number, judge name, volunteer name. Some other things to note within the CourtWatch app. We are asking whether a party presented corroborating evidence. Corroborating evidence is basically any evidence that is more than a party's testimony. So I am saying that Paige hit me in the face. Okay, that is evidence, that is testimony. Do I have anything to back that up? Do I have medical records? Do I have a friend that saw Paige punch me in the face? Okay, that is corroborating evidence. If that is presented, we'd like to know whether that has been shown. Okay. If there's any objections that are made during the hearing, copy what you hear. You don't need to know what hearsay means. You don't need to know what relevance objections means. You don't need to know at all what they're saying. You can just type it verbatim. Okay. This is because we utilize CourtWatch in partnership with the DV Leap, which is a appeals project within DC that is dedicated to appealing bad rulings in civil protection order court. The as Paige said, there's over 5,000 protection orders heard each year by the protection order court. So the project's not going to know which cases to bring or which cases to look over unless somebody points them to it. CourtWatch is endeavoring to help DV Leap figure out which cases they should look at for possible appeals. And what they want to know is whether evidence has been presented, whether any objections were made, because those are appealable things.
So one thing that we didn't talk about too much, so one of the questions we ask is a U.S. Marshal present? There's lots of types of security that are present in the courthouse, particularly what we're looking for this. Marshals are inside the courtroom, so they're the ones that are responsible for the safety of people inside of the courtrooms. They're going to be wearing typically khaki pants or shorts, depending on the season, and some kind of navy-ish top, whether that's a jacket or a polo shirt. We want to know, was the marshal present for the majority of the time that the petitioner and the respondent were standing in front of the judge? Again, we're looking at this from a safety perspective, so that's the enforcement figure that we're looking at for that particular question.
And another thing I forgot to mention is whether parties cross-petitioned. Cross-petition is when each party files a protection order against each other. So both parties are petitioners, both parties are respondents, basically. And it is a common tactic utilized by abusers to muddy the waters in a civil protection order hearing to either further oppress their partner or to get out of the system, right? Having a judge throw their hands up and saying, well, neither of you are going to get a protection order, or both of you are going to get a protection order. And so what we want to track is how often respondents are cross-petitioning and what outcomes lead to that cross-petitioning, and bring that to the judges and how they rule when one person has filed against their petitioner. So ways to figure out whether a cross-petition has been filed is you will see on the docket the same party names just reversed, one after the other, okay? They might even say in the hearing that there is a cross-petition, or they will say that there are two protection orders that are being heard at the same time. 90% of the time, a judge is going to hear a cross-petition, both petitions at the same time in the same trial. So really be on the lookout for that.
Then lastly, too, we're asking you to identify certain demographic information about both of the parties. So we're asking you to make your best guess about the petitioner and the respondent's gender, their race or ethnicity, their primary language, their perceived age. They're not going to give this information out directly during the hearings. We're asking you to make your best guess, because ultimately we are looking at this person the way that the courts are looking at this person, and we want to see how the court is interpreting this person standing before the judge, how the judge is interpreting them, because again, when we're looking at this aggregate data, we want to see if different identity pieces in aggregate create different results for folks getting protective orders.
Right. Just to drill down on that, right? If somebody looks to you to be transgender, click the box, because it may appear to be transgender to the judge as well. You don't have to verify that that person is actually transgender. You don't have to verify whether that is an LGBTQ relationship or not. If it appears to be an LGBTQ relationship, even though they're saying that they're just roommates and they're just sharing a residence and there is no romance involved, if it looks to you like it is an LGBTQ relationship, mark that off.
Because ultimately, if you're thinking it, the judge is probably thinking it as well, and that in some way might affect their ruling. And so that's really what we're looking for.
Okay. Basically to the point, what you see if it influences the judge, okay? Honestly, mark it off. Mark it off. If you think that the judge has ruled one way or the other, if anything really comes to mind, mark it off. Okay. All right. If there's anything that worries you about the case that DC Safe, our advocates should follow up on, please mark it in the CourtWatch tablet and go and get a safe advocate and let them know, okay? The advocates are endeavoring to follow outcomes and follow court proceedings for client safety, but they can't follow everything. They're being pulled in a million directions. If somebody needs to adjust their safety plan or need to talk to an advocate about a surprise court outcome or what the court has done, we want to make sure that the advocates can meet with those people, okay? Yep. That's the one time you're really allowed to just go and get a safe advocate, okay?
And a couple of other notes, especially for our Georgetown Law participants, there might be a point where the judge asks, is there an advocate in the room, or is there a Georgetown Law student in the room? We're not talking about the CourtWatch volunteers. There is another volunteer project through Georgetown Law where they provide legal advice at CPO hearings. That is not your role as a CourtWatch volunteer, so that's not what you will be. You'll not be raising your hand if the judge asks for either of those positions.
The judge will never ask for you.
Yeah.
Okay. There is at no time is a judge going to be asking for you unless he or she directly points at you or says you with the tablet. There is no reason for you to raise your hand or stand up. Okay, and that's about it for the tablet training. Just real quick, for the court procedures or court policies, please dress nicely. You don't have to be in a suit and tie, but please don't come in jeans. All right, come wearing something nice, because they're going to immediately identify you as being with us at DC Safe because you have a big tablet that has our sticker on it. Okay, so present yourself well. You can sit anywhere in the courtroom that is behind the bar, and you'll see the bar is just this big half wall. Okay, behind that you can sit as close to the wall or as far away from the wall as you want to do. Please do not talk to anybody. Stay silent, and only utilize your tablet for CourtWatch purposes.
Yep. In case you need to get anything to eat, you need to take a break, there is a Fire Hook, the bakery and coffee place, on the C level. So that's two levels down from the first floor where the hearings are being heard. So if you need to take a break, you can head down there. Don't bring your food into the courtroom. You'll need to finish it before you enter into the courtroom.
And no gum at all, please. Just think about it if you are going to go to work, right? Just be professional, be courteous. If anybody asks you any questions from the court, you can ask them, but don't be afraid to say, I don't know, or let me get an advocate, or I'm sorry, that's not what I'm here for.
Yeah. So when you come for your shifts, you're first going to come up to the 4th floor to our main intake center office. You're going to say you're a CourtWatch volunteer. A supervisor is going to come out. They're going to have you sign up. So we are going to ask for some form of ID when you take a tablet. We're going to make a copy of your photo ID. We're going to have you sign out the tablet, and then we expect you to bring it back, and at that point we'll sign you back in. Once you get the tablet, you're going to head down to the courtroom, and you're going to start observing at that point. If you have any questions at any point, if anything comes up, you can always come back up and ask to speak to the supervisor in the intake center. And we really appreciate this work. If you check out, along with this video, I'm going to send out our link to the CourtWatch blog, but this is a great way for us to be able to do systems advocacy. So we are so focused often on the direct services piece. The CourtWatch project and the volunteer work that you all do really helps us in looking at the bigger system, and really trying to make sure that we are advocating as best we can for the protective order system to be the best for the survivors that are seeking safety through it that it can be.
Thanks again, and we appreciate all of your help during this academic semester. If you need verification of your time worked, you can email us. Yeah, you can email us, but what we need you to do is email us the form you need us to fill out, okay? We're not going to generate any product for you. Anything that you need, any requirements that your professor sets or your clinic sets or your program sets, you are going to make your own form and give it to us, and we're just going to fill it out and give it back to you, okay? And also note, for those law students who are looking for pro bono hours for the New York Bar, this is not assisting indigent personnel people personally, so it will not qualify you for the New York Bar pro bono hours, okay? And so unfortunately we won't be able to certify you for that. But any other questions regarding certification or anything like that, don't feel free and don't hesitate to email us.
And again, thank you so much.